Hello, my name is Michael Tesoro, and I've prepared this video presentation about the most recent report by the ACCC as part of its Digital Platforms Services Inquiry, which is looking at general online retail marketplaces. A bit of background about myself: I'm a competition and consumer lawyer. I've been running my own practice for 13 years, and I help companies with competition and consumer law matters. Prior to that, I worked at the ACCC for 15 years, and I had a variety of roles there, including as a Director of Enforcement. So I'll be seeking to bring my expertise as a private practitioner with Tesoro Legal Consulting, as well as my ACCC experience, to bear on this report. Now, the outline of the presentation, I'll start off with a short introduction, then provide an outline of the report, looking at the main issues, and then finish with some commentary. As I said earlier, this is part of the ACCC's broader digital platforms inquiry, which arose as a result of the Treasurer giving a reference to the ACCC to look into all aspects of digital platforms. They've issued 3 prior reports, including one on ad tech industry, and this is a 4th report, which is focusing on these online marketplaces. And even though it's looking at this industry, it is really focusing in on 4 providers: Amazon, Catch, eBay, and Kogan. And there's a couple terms which need to be understood so you can understand the report. The first is the idea of the hybrid marketplace. So effectively, a hybrid marketplace is one that sells both third-party independent products on behalf of sellers, as well as selling their own products. So there's 2 types of products being sold on the platform. And Amazon, Catch, and Kogan are all classified as hybrid sellers because they have their own products next to third-party sellers. And the exception to that is eBay, which doesn't sell any of its own products, so it's not considered a hybrid. The other concept is multi-homing, which I think can be understood 2 different ways. Firstly, that sellers are not locked into a particular online retail marketplace. So sellers don't have to only sell their products through Amazon or eBay. In actual fact, most sellers do sell their products through a number of different platforms. And also, buyers are in no way locked into particular marketplaces. So as we all know, marketplaces are used by consumers to buy products depending on where they find the best product. So there's a lot of movement between different marketplaces by consumers. Now, the key finding made by the ACCC was that the market had not yet reached a situation where any of the players had achieved a dominant position in the relevant market. So it didn't identify any specific competition concerns. However, it did suggest that there's a tipping point at which one of these players may achieve a dominant position or market power, and then some of the practices which it identified may create competition concerns. But the key thing about the market is just how much it's grown over the last couple of years. As you can see there, the 1920 period, the market was a particular size, and in that 1-year period to 2021, it had grown approximately 30% in just 1 year. And now the market is estimated to be worth $52 billion a year. The other thing you can see from that graphic is clearly that eBay has most of the sales in the market, over $5 billion worth of sales, whereas the other 3 major players in the market combined don't have the same sales as eBay. But a significant development is the level of growth over the last 12 months amongst the various players. And as you can see there, eBay has grown quite conservatively over the last 12 months, only 6%, which is still a respectable growth rate. However, the other players have grown much more significantly, both Catch and Kogan in the 40s, but probably most notably Amazon has grown 87% in the course of 1 year, which is a significant amount of growth. Now, the way the findings and observations were presented in the report, I found a little bit hard to follow. So what I've done is I've sort of broken it up into various topics, and I'll discuss each of the topics in turn. The first topic is the use of the algorithms by the marketplaces. And obviously, as we understand, algorithms are supposed to take search terms as inputted by consumers and then find the most suitable product. And that's supposed to look at issues like price, availability, suitability of the product, maybe prior pricing or historic purchasing decisions by the consumer. But what the ACCC found as it looked at both the Catch and the Kogan algorithms was they would actually self-preference their own products. So in relation to Catch, they identified that the search algorithm would also factor in such issues as the high conversion rate of products which were sold by Catch, and as well as Catch one-pass eligible products. So here you've got a search algorithm which doesn't simply address or respond to the buyer's search terms, but imports an additional consideration which advantages Catch. Kogan similarly had a boost for its own products, and it's actually quite transparent about this. It is mentioned in their terms and conditions for sellers that they will prioritize products that are their particular products. Now, the interesting thing here is that Amazon refused to provide the ACCC with its algorithm, but they did claim that they don't engage in any self-preferencing. So the issue here, I think, is that because of the size of these companies in the relevant market at the moment, this self-preferencing which appears to exist does not cause any competition concerns for the ACCC, but it could cause problems in the future if these companies develop and expand their operations and achieve a level of market power in the industry. Now, there was another concept explained in the report about buy boxes, and these are described as a process where marketplaces generate a single page of products provided by different sellers and sort of compares them side by side. And that's a very valuable feature for consumers because they want to see all the different products in a particular category which are available and then compare them and decide on which one to buy. And then what the ACCC identified here was that whilst the buy box had the appearance of being this objective search result showing different competing sellers, a number of the platforms had terms and conditions around the operation of their buy boxes, which gave preference to particular third-party sellers who had entered into agreements with the marketplace sellers to purchase additional services. So, for example, with Amazon, they would allow companies to be featured on the buy box who had met various performance metrics in terms of delivery. So fast delivery meant they'd be featured in the buy box promotion, but in order to improve your delivery times, you would invariably have to sign up to fulfillment by Amazon, which is an additional service that Amazon offers. Similarly, Catch would advantage products where the customers had signed up to the Catch Club membership or entered into other arrangements. Furthermore, with eBay, they would identify sellers on the basis that they had subscribed to fulfillment by eBay. There was further things identified by the ACCC in relation to Amazon. So effectively, in order to feature in these buy box promotions, sellers would have to meet these stringent requirements, such as being a subscriber to the Amazon professional selling plan, also meeting particular metrics in relation to defect rates, cancellation rates, etc. So you have these additional requirements being imposed on sellers in order to feature in the buy box promotion. which is sort of a skew of the understanding which consumers have that the company's products which appear in the buy box are actually responsive to their search terms. There's these other issues being brought in unbeknownst to the customer, and also the marketplaces are gaining revenue from providing these third-party vendors with advantages. There was an observation that if a seller subscribed to fulfillment by Amazon, their offers would be immediately eligible to be in the buy box. And there was also a concern about the introduction of the Prime eligible program through Amazon, which was again giving third-party sellers access to some of the lucrative Amazon sale events, such as, the lightning deals and Prime Day and the very well-known Black Friday sales and Cyber Monday sales. So on those days, consumers doing a search on these sites expecting to get a organic response to their search terms, and in actual fact the range of offers that are available in those days has actually been narrowed by these companies signing up to various additional services from the marketplace providers. So as you can see, the ACCC believe there may be a risk to competition in these markets due to the requirement to sign up to these fulfillment services, and this has been something that has caused concerns in other jurisdictions. And the ACCC saying here that if Amazon develops its market position in the future, that this could become a competition concern. The next issue was the price parity, and they identified in their report a practice of requiring sellers to enter into agreements not to sell their products on other competing marketplaces at a price lower than they're selling it on the initial marketplace platform. So these agreements make sense. Obviously, a marketplace doesn't want to be seeing products on its marketplace being sold elsewhere cheaper, but the obvious conclusion here is that this does reduce some level of price competition. And so this is a practice which, again, when a company achieves a level of market power in this relevant market, could be anti-competitive and create detriments to consumers. Next issue was a discussion of the pricing algorithms which sellers use, and the ACCC identifies 3 different types of ways of importing an algorithm to set the prices for products by sellers. And the first way is to use their own algorithm, which is fairly unusual thing to do, given there's quite a bit of technical skill required to write an algorithm. You can also select inbuilt pricing algorithms that the marketplaces provide on a drop-down screen, so you can choose an algorithm to say, I'll set my price 5% cheaper than my major competitors, or something like that. Then you can also go to third parties to buy a pricing algorithm. And the ACCC had some concerns about the way this could work, particularly in relation to what they call dynamic pricing algorithms, which are algorithms which scan for various factors in the market and automatically change the pricing for the seller's products. And the ACCC identified a particular concern about the way that these dynamic pricing algorithms could actually be used to support a collusive agreement between sellers. So effectively, the concern is that if there was some collusion in an industry and the algorithms were being used, they could be set as a way of exposing a departure from the price fixing agreement. So one of the big reasons that price fixing agreements fall down is that participants cheat on the price fixing agreement, and it's very hard to monitor departures from the agreement. But the benefit of a dynamic pricing algorithm, it could immediately alert other members to a cartel that somebody's cheating on the cartel agreement. So they had a concern about collusion, that it would enable new forms of coordination, which they described as algorithmic collusion, which has been a lot of stuff written about that. They're also concerned about the possible for price gouging, and they make reference there to the COVID pandemic and a lot of alleged gouging in relation to various products like hand sanitizers and rat tests and so on. And also this idea of setting your prices depending on the personality type features of the consumer. The second two concerns don't sound to me like a competition concern, so I've really only focused on the first one, which is the dynamic pricing algorithms in the context of monitoring or monitoring a collusive arrangement. The ACCC was also arguing that dispute resolution processes used by the marketplaces have to be improved, and they referred to their earlier recommendation that there needs to be more robust mechanisms in place amongst digital platforms generally, and also a second tier source of dispute resolution, some sort of ombudsman. So they reiterated that idea many, many times, but it didn't seem to me that the evidence was really there that there was a problem. The mechanisms in place for consumers to complain to these marketplaces about poor service from a seller seemed to be quite advanced and quite effective, and there didn't seem to be a clear indication of a problem between sellers and marketplaces, and the fact that disputes weren't being resolved in a fair way. Now again, the ACCC said that if there is a growth in market power and then maybe there could be a problem arising in the future, but they focus more on the fact that if a seller is treated unfairly by a marketplace, it could have very dramatic effects on its business. I think here the evidence is really not available to argue that a change is needed. Now, one thing that ACCC drew attention to was something that was involved in bringing in a few years ago, which is the Product Safety Pledge. And it was a voluntary scheme that the ACCC devised and put out to the market, really trying to get marketplaces to be more proactive in terms of addressing unsafe products sold through their marketplaces. And a few companies sold up. I think 3 of the companies that are the subject of this report, Amazon, Catch and eBay. Notably, Kogan hasn't signed up, but this is to involve these companies in being very vigilant in looking for unsafe products on their websites and taking quite immediate action to remove them from sale. So I think the purpose of the ACCC drawing attention to this is that a code of conduct along these lines could be introduced to militate against some of the risks associated with self-preferencing and other types of arrangements that could cause problems in the future, particularly if one of these companies develops market power. So I thought it was interesting analogy to draw that this has been a big success, the Product Safety Pledge, and clearly further initiatives along these lines could be considered in the future. Now, the main issue that the ACCC finished its report on was the concern that there might be a tipping point at which Amazon does develop market power in the relevant Australian market, and that's based largely on its growth over the last few years. And it acknowledges, ACCC acknowledges that, you know, it shouldn't be punished, Amazon shouldn't be punished if it outcompetes its rivals. However, if they were engaging in anti-competitive conduct, then that would raise concerns. If they become a gatekeeper with a dominant position in the market and they engage in some of this conduct, primarily tying arrangements, if they are also engaging in self-preferencing and other things, then that would raise competition concerns and the ACCC would have to intervene. So given the ACCC didn't find any problems currently, it didn't really go to the next step and make any proposals for changes. I think that would have been premature given that it didn't find any anti-competitive issues at the moment. I think it's quite interesting that the ACCC has concluded that there isn't a problem at the moment, because whilst there may not be a competition concern, the fact that these platforms may be self-preferencing without the knowledge of the users of the sites, the consumers, is, I think, potentially a misleading, deceptive conduct issue, potentially an unconscionable conduct issue. So when a consumer enters their search terms, they're expecting to get a series of search results that is responsive to its terms. Unbeknown to the consumer, there's actually other factors coming in there and influencing those results. It may be the self-preferencing of the marketplace's products. It may be the fact that sellers have entered into arrangements with marketplace sellers in relation to fulfillment, or signed up to various premium additional products. So all that stuff isn't disclosed to consumers, and the search results which they're getting are not really what they're expecting. So I thought that was an issue that I expected the ACCC to focus on, but it really didn't. The other issue that I was surprised at was they didn't really explore any potential changes that could be introduced in the event that one of these companies does achieve a position of dominance or market power in the market. And I guess that makes sense to the extent that they didn't identify a current problem. But I thought in an article that was very worthwhile to look at if people are interested in this issue is this article by Toshiaki Takigawa from Kansai University in Japan, entitled "What Should We Do About E-commerce Platform Giants?" And it looks at antitrust and regulatory approaches in a number of jurisdictions. It's a very good article, and it's obviously strongly arguing for a traditional competition law-based response to the issue of e-commerce platforms, and dismissing the benefits or challenging the benefits associated with taking a regulatory approach. But it does have some interesting insights into some of the things that have occurred in other jurisdictions. For example, there's reference to action taken in China to effectively ban this approach which Alibaba was taking in that market, which required sellers to pick one from two. So effectively, customers on the selling side were required to choose either Alibaba or Tencent, and they couldn't be on both. And the government stepped in and banned that practice, which was very effective. It saw a significant decline in Alibaba's market share as a result of that change. Then he identifies a few code of conduct type approaches which are being discussed in the UK that haven't actually come in yet, but its ideas about providing some partial data sharing to assist other companies to enhance their search algorithms. Let's talk about Google providing click and query data to third-party search engines. So the implication is maybe that other information could be made available to enhance competition in the market. Also, he talks a lot about the concerns in the US about the introduction of the Amazon Prime bundled offer. So as people may know, Amazon Prime is effectively a video on-demand service which is very popular, and the way that has been bundled together with other products and providing bundled discounts. And it's quite controversial in the US because there's been comments by various members of Congress complaining that this is exclusive dealing, predatory pricing. And the question is whether this type of approach is going to result in the achievement of a significant degree of market power as well as anti-competitive outcomes. So the introduction of Amazon Prime in Australia, if the company develops more market share, could be of concern. And he also refers to an initiative in Japan by the JFTC, which is called the Superior Bargaining Position Abuse Guidelines, is a fairly lengthy name, but it's looking at ways of preventing various larger parties from taking advantage of their superior bargaining power to damage other players in markets. And there's a focus there on big retailers forcing suppliers to engage in particular conduct. A lot of the conduct that's been identified in this list of itemised practices seems to have some resonance to the ACCC's cases against Coles, where they were forcing suppliers to provide money for promotions and things like that. But it is an initiative that, you know, the author of this article suggests has been tried in Japan and may be something that could be considered a list of particular practices which are through a code of conduct or some guidelines not permitted to be engaged in. So I strongly recommend having a look at that article. I thought it was very, very good. It takes the ACCC's report to the next stage, looking at both the pros and cons of a competition response as opposed to a regulatory response, as well as looking at some of the initiatives that other regulators have experimented with and assessing the benefits of that. So that's all I've had. I thought it was an interesting report. I thought it wasn't very well structured. It was hard to really get a handle on what the ACCC was saying. But I think this presentation does pick out, I think, the main findings and where we are at the moment. That as the market develops, some competition concerns could emerge, and if so, there may be a need for some sort of intervention, whether that's a competition law intervention or a regulatory intervention. So if you've got any questions about this presentation, please feel free to give me a phone call or drop me an email. Bye-bye.